It might be not hurt many that when the court finds there is institutional corruption, systematic fraud played, starting from 10-2014 to selection, allegedly the result was declared, but there was no panel, there was no merit list, there was no category-wise merit list, no division of numbers, and or rank was given to anyone.
This channel does not promote or encourage any harmful or illegal activities. All contents provided are strictly for educational and informational purposes only.
14th of September 2016, the result of TET 2014 was published, but no merit list and scorecard was given to anyone. On 26th of September 2016, notification was published for appointment of primary teachers from TET 2014 to fill up 42,949 vacancies. In that notification, it was clearly stated that the candidates with minimum qualification as specified by MHRD will get preference, and after that, eligible candidates with relaxed qualification may be considered. It is needless to mention, is important, that MHRD gave relaxation only till March 2016, and in spite of that, the board notified that the candidates who do not have training will be considered too. Notification proves that the board decided to get benefit of relaxation to TET 24 qualified candidates. I shall place this notification later. Then paragraph 10 is important. Your petitioner states that after notification, the procedure was started for appointment, and from October to December, the interview and verification process started, and on 31st of January 2017, allegedly, the result was declared, but there was no panel. There was no merit list. There was no category-wise merit list. No division of numbers and or rank was given to anyone. In website of the board, there was a dedicated space where the person could see whether he or she was empaneled or not. No merit list was ever published. And in spite of repeated requests, the full merit list was not made to the public. Allegedly, it was stated on 30th January 2017, list of trained candidates were published. On 4th February 2017, list of non-trained candidates other than the Bengali medium was published. And on 8th of February 2017, list of non-trained candidates and candidates from Bengali medium were published. From the dates and list, it is clear that all trained candidates of 2014 were appointed to the first list. And after completion of the same, as per notification dated so and so, the board appointed non-trained candidates. Then Lordship may come to paragraph 11. Just I am reading out, Lordship need not be detained for that. In paragraph 11, down the middle, it is alleged that thousands of non-trained students were appointed, and petitioners, though similarly placed, were ignored. If it is the stand of the board that no non-trained candidates can be appointed, then all appointments of non-trained candidates made after March 2016 are bad in law. Then paragraph 12. Your petitioner state that recently TET 2014 scam busted in West Bengal, and from several cases lodged by CBI and from several orders passed by this honorable court, the petitioners came to know that several illegal appointments have been given by depriving the petitioners. Non-trained candidates are the worst sufferers of this scam. On 23rd December 2020, the West Bengal Primary Education published one notification for recruitment of 16,500 primary teachers. And in that publication, they have stated that the candidate should possess qualification as per guidelines of NCTE. Such notification is illegal. I am just skipping over. Then Mr. Y was empaneled. A person named Mr. Y having roll number such and such was empaneled by the board. It also proves that huge corruption took place. As per the action of the board and as per the different statements given by the president of the board, Mr. So-and-so, all trained candidates were recruited. And as per the notification of the board, the petitioner should get a fair chance of recruitment, but the board has done a complete injustice to them. Then paragraph 13.
Then what was the allegation of the petitioner? 2014 was corrupted. It is your allegation.
TET 2014 corrupted, and even the selection process were.
Paragraph does not say so.
Yes.
Paragraph says that it is TET 2014 corrupted.
And then followed by, if I may, followed by they say, yes, once again, Milord, kindly come to paragraph 11. Several non-trained candidates were appointed.
Yes.
Now, the Lordship will go by the principles of a deemed pleading. I shall satisfy from authorities that the court, whose duty is to, Lord, find out the truth, should not strictly confine to the words of the pleading, but they have to also consider the deemed pleading. Here, pleading is categorical. Apart from 2014, where CBI investigation is going on, I shall also place the CBI charge sheet. Even in case of selection, non-trained candidates were appointed. Then the paragraph 12, about example given to Mr. Y. Now, this Y is relating to recruitment in 2016 selection process.
So if it is to be deemed that the 2016 process was also under, then where is the prior to that effect?
Yes. Now, may I place little more?
Just a question.
Yes, Lord, kindly come. Let us come to the prayer of the repeat. No, it's better to satisfy the queries of the court first. Lord, kindly come to the prayers in detail. I to direct the authorities to file a report disclosing name, numbers, rank, category of all non-trained candidates who have been recruited till date in primary schools from date 2014, including the date of recruitment. Then direct the authorities to treat the petitioners equally with non-trained candidates who have been recruited by the board after expiry of the relaxation period.
That we understand.
Then kindly come to Lord 4.
By giving the same benefit.
5 is important. To direct the authorities to publish a merit list by maintaining full transparency regarding TET 2014 recruitment.
TET 2014, you are qualified.
Sorry, Lord, I skipped Roman 4. To recruit the petitioners by giving them same benefit by which other non-trained candidates were recruited by the board following the rules dated 22nd March 2016 and appointment notification dated 26 September 2016.
So your challenge was that either give those persons or the similar benefit like the untrained, non-trained candidates were.
Okay. But my prayer is everybody is charged. To recruit the petitioners following the appointment notification dated 26 September 26, very important.
So what is the kindly address us that on the basis it seemed to us as it was argued that TET 2014 allegations are there, nothing to do with the selection.
Yes,
and that they would be satisfied in the event they are given appointment like those non-trained in the remaining.
No, but my argument would be, it might be not hurt many, that when the court finds there is institutional corruption, systematic fraud played, starting from 2014 to selection, then I shall develop that. Now, to maintain the purity of the system and keeping Article 14 and 16 in the mind, court will be non-hesitant to set aside everything and do it afresh. Now, yes. Now, I am just to complete the paragraph 12. I have given the instance of Y, then 13. Your petitioner stated the candidate, namely Pulao Sarkar, was not empaneled. Another candidate named Dhiraj Bandyopadhyay having roll number was not empaneled. Bishwajit Burman having roll number was not empaneled. But they were called by the department for verification of documents, and from sources, the petitioners came to know that they were working as primary teachers. Now, this is fundamentally attack on the entire selection process. But how these were dealt with by the affidavit, I shall place it. Then this paragraph 13 says there was huge illegality.
Paragraph
13. Well, though there was huge illegality in the whole selection procedure of, it should be take not 2014 selection process 16, and everything happened as per the wish of the board. And for this illegality, the candidates like the petitioners could not get appointment as primary teachers. Therefore, this relates to the selection.
yes.
Then we'll have a serious allegation in paragraph 15. Your petitioner further states that on 30th April, so-and-so, I am not naming, made a statement before the media pointing irregularities in Tate panel. Recently, a person lodged a complaint against one MLA of All India so-and-so. That MLA took crores of money from job aspirants with a promise to give them government job in school, and in that case, personal assistant of one another MLA was arrested. The Constitutional Court would definitely will not go deep into it to do complete justice and uphold the constitutional principle. Then paragraph 16, your petitioner states that the TET 2014 examination is the biggest scam in West Bengal since 2011. Then Lordship may skip over paragraph 17. Your petitioner states that TET 2014 is the biggest scam of the education department so-and-so. MLA, MP, leaders of ruling party are involved, and meritorious students who qualified for the job did not get chance. And after talking to the candidates, petitioner came to know that roughly such and such amount was given for job in TET 2014. And continuing paragraph 18, the statement is made an absolute fraud was committed by the West Bengal board by not publishing merit list in respect of, it should be without selection qualified candidates.
Where you are reading, Mr.
Without paragraph 18, last two lines.
Yes. Merit list of date 2014.
Without 16, selection 6. Then kindly turn to without paragraph 22. Without 22, last three lines. I am not reading the entire thing. Your petitioner states that the respondents and each of them acted illegally, arbitrarily, and unconstitutionally in appointing some candidates who did not even sat for TET 2014. Serious allegation. Now, from the cans which were admitted by the court, I have prepared a list only to show that how many rank jumping was there. I shall place that. I have given them the copy also. Now, in the background of this pleading of the writ petition, now kindly takes up the affidavit filed by the board. That is in volume 2. At page 359. Now, that I would make this submission, probably it might be repetition, that an authority or institution always go by institutional memory. They do not go by individual's memory. And when an authority affirms an affidavit denying the responsibility of the previous period, it seems he admits, my lord, that there were some irregularities. I just place the language. I say that, paragraph 3. I assumed office at the President of West Bengal Board on 24th of August 2022. I was not the President of the board when 2016 recruitment process was instituted and subsequently completed. The court did not want to know that whether you are responsible, but the institution was responsible. Then from records available in my office, it is evident that in the 2016 recruitment process, marks were given by the selectors, both in interview as also in aptitude test to the candidates. I would appeal to your lordship to read between the lines. Then based on such records, I submit with utmost respect that the coherence which can be drawn thus far from such grant of marks by the selectors for aptitude test to candidates, thus far thereafter within the bracket, from such grant of marks by the selectors for aptitude test, is that such aptitude test was held. He does not positively say that from records, it is apparent that the aptitude tests were held. He wants to draw an inference on the basis of what? Since marks were allotted. Then paragraph 6, he now says what steps has he taken in 2022 recruitment process. And it's interesting, my lord, would please to read. In the 2022 recruitment process, which commenced after I assumed office, the board has taken various steps which are first of its kind. Therefore, it's an admission that these measures which would have protected the selection to maintain its fairness was not there. Then the interview and aptitude test of a candidate for the 2022 recruitment process is being taken, but I am not concerned with 2022. He was supposed to answer from records about 2016. Therefore, without this affidavit, in my humble submission, my lord, clearly admits then kindly come to 363, another affidavit by the president. Here, my lord, he describes from several authorities what aptitude test mean. I am kindly not troubling my lord with this huge quotation from great authorities. I am not at all interested. Kindly come to paragraph 12.
It's 325. The 370.
The second direction contained in the order dated 24th of January 2023, passed by this honorable court, directs me to submit the list of interviewers at page 375.
I'm just wanting to see the 24th January order.
Yes, 24th January order, my lord, he was directed to file affidavit explaining the situation. 24th January order.
Yes.
The page 423, I am thankful to my friends.
Yes, Mr.
Yes. But the order says, in course of hearing, a serious allegation was made by the petitioners that in the selection process of 2016, the stage of interview and aptitude test came, only interview was taken and there was no aptitude test. Though in aptitude test, there are 5 marks. As a large number of petitioners were present in the courtroom, I decided to exercise my power under Section 165. Oath to 7 of such candidates being so and so, so and so. This is the order.
Yes.
Yes.
Now you are showing us para 12.
Yes. The second direction contained in the order dated so and so, passed by court, directs me to submit the list of interviewers who interviewed, took the aptitude test, so and so. I say that 2016 recruitment process was a district-wise selection. 2022 the center. Now they say 2016 was district-wise selection based on the opted districts of the applicant and candidate. The interview Vivabosi aptitude test was conducted at centers under the respective district primary school councils. And there is as such no distinctive record which was kept and maintained in such recruitment process, wherefrom it can be ascertained as to which interviewers took Vivabosi aptitude test of a given candidate at a given center in a particular room. In 2016 recruitment rules, no methodology was suggested. This is the difference. Are required to be maintained by the examining body. However, a full and complete list of interviewers available with the board. Only board maintains at the center the list of the interviewers. And they don't have any record to show at all the interview was taken or not. That is admission. On the face of such a serious allegation, when the court directs to file an affidavit, not an authority who is entrusted by law to hold the examination fairly in compliance of Article 1416, files this affidavit. Now, here, my lord will not find anything about the allegations made in the petition. Maybe that this was not directed to be do so. Then kindly come to another affidavit at page 378 by Dr. Partha Karmakar. Here he deals in detail. Now that he meticulously takes the point, it's not maintainable, this and that. Because the state authorities, when takes the point of maintainability, that should really raise doubt in the minds of the court about their transparency and impartiality. Kindly turn to page 389, paragraph 9 of the, sorry, before that, I missed one paragraph. Paragraph 8. Their whole attempt is to see that the petitions are knocked out on the ground of maintainability. These issues have been considered by the court. I shall come to later. They say in paragraph 8, that Rule 6.3 is applicable to all applicants who applied in 2060 recruitment process. There is no challenge in the said petition to Rule 6.3 of the 2060 recruitment rules. But why should I challenge? I rely on this. I rely to show that 6.3 has been blatantly violated. I shall test that. Then again, paragraph 9. But if I use this term, kindly excuse me if it is not suitable. But it's a fantastic defense, paragraph 9. I say that applicable recruitment rules of 2016 made in exercise of delegated legislative power by the School Education Department, Government of West Bengal, never mandated the answering respondents to publish in public domain the panel, merit list, category-wise merit list, breakup of marks, rank of candidates as contained in the petition. Now, this is an admission that they did not do so. They say that we have not been Done. Delegated legislation does not provide us to do so. Transparency, go ahead. Article 14, 16, go ahead. And then further, the recruitment rules 2016 has not been challenged in the said petition. Such being the position, the answering respondents cannot be faulted not to have caused publication of the above in public domain. It's a clear admission they did not publish. However, in terms of the directions passed by the Honorable Court, the answering respondents did publish breakup of marks for candidates who were recommended from the 2016 recruitment process.
2022.
And that too, my lord, in terms of order dated 2022. And that's not the complete list.
Page 389.
389 to बोल रहा हूँ. Then paragraph 10, as I said, the defense of the recruitment authorities not to come up with records and say petition is not maintainable. I say that till paragraph 10 of the said petition, in paragraph 10 of the affidavit, the alleged grievance of the 140 petitioners were those which centered on 2016 recruitment process. In paragraph 11, the petitioners are leaped into 2020 recruitment process and made certain amendments. There is no amendment in said petition. 2020, we are not concerned. Then, in the 2020 recruitment, no untrained candidates are eligible to apply. That's not our grievance. Our grievance is 2016. Kindly come down to my lord, 3 lines from the bottom. On the date of affirmation of the said petition, I got it. 4 lines from the bottom. On the date,
Yes.
on the date of affirmation of the said petition, the petitioners are all untrained candidates who were unsuccessful in the 2016 recruitment process. In such view of the matter, the petitioners, as a matter of fact, not made out any case which calls for an interference by the Honorable Court. No denial of allegation of fraud and, all scam. Then, petitioners have failed to demonstrate existing any judicially enforceable legal right or breach in performance of any respondent legal duty warranting issuance of mandamus by this Honorable Court. It is categorically denied that the answering respondents intentionally ignored the petitioners as alleged or at all. It is categorically denied that although thousands of untrained candidates were recommended, the petitioners, though similarly placed, were ignored as alleged or at all. It is categorically denied that the relaxation given by NCT is applicable to all TET 2040 candidates who qualified TET as alleged or at all. On the contrary, it is stated that the relaxation given by the NCT applied to those applicants who applied for the recruitment process. This is a fraud on statute. I shall explain. Then will kindly skip over. I am not detaining with further readings. Page 392. Well, that 4 lines from the top. Unless further details. Now, my lord, now the burden is thrown upon the candidates that they have to get all details. Unless further, got it? Unless further details are furnished by the petitioners pertaining to alleged Mr. Y, having roll number such and such, the answering respondents are unable to deal with such statement temporarily, reserving their right to deal with the same subsequently upon disclosure of further details. What nonsense is it? Records are with you. You are privileged with the records and you want me to produce it. Is that the law of evidence says? The answering respondent have no knowledge about the alleged different statements given by its previous president, and accordingly refrain from making any comments thereon. Such refraining, it is made abundantly clear, is not an admission of the statements. The answering respondents further say that the petitioner failed to establish that there has been any pick and choose between the candidates. I have given 2-3 examples. You could have come up saying that his marks is X. We have given appointment to Y. Y is higher than X. And now there are 100 writ petitions pending before this court. To summarize everything, I have just prepared below the chart of rank jumping. I shall hand over to it, Lordship, to your Lordship. This is the affidavit in detail by the board. Kindly come to the paragraph 19. The specific pleadings in the writ petition when they were touched. It is stated that by the order
Page 395.
396, paragraph 19.
Yes.
It is stated by the order dated 20th December 2022, this Honorable Court directed the answering respondents to come up with the particulars in tabular form. The marks obtained by last empanel candidates of different categories and different mediums of all districts. In compliance thereof, the answering respondents with a memo dated so and so submitted the list of petitioners along with the breakup of total score together with the breakup of total score of the last empanel candidates in the respective medium, category and district wise. The said direction was furnished in a tabular format before the Honorable Court. Such report is annexed. It is then, my lord, if upon examining the said tabular chart, further queries are required to be addressed, the answering respondents are willing to explain them. Is it not withholding? The court will direct, then only you come up with your defense. The answering respondents categorically deny that the report is absolutely bogus as alleged at all. It is clarified that if at any stage of the selection any ineligibility is detected by the examining body, then the candidature of the applicant can be rejected at any point of time. It is not a correct appreciation of the position of law that if at the time of scrutiny or verification a candidate clears his scrutiny verification, he or she cannot be declared as ineligible before or even after being recommended. In other words, if a candidate upon crossing the hurdle of scrutiny and verification is permitted to sit in the interview aptitude test, the right of the examining and recommending body to recheck, revisit the candidate eligibility is not wiped out. Any allegation against such a contention is emphatically denied. Furthermore, a candidate is rejected, the examining body is obliged to inform him the reasons, see the audacity. The reason of such rejection under the applicable statutory rules. It is categorically denied that the report filed by the examining body is absolutely bogus as alleged at all. It is further denied that the report is absolutely false as alleged at all. Well, the denial is that it's not absolutely false, partially false. The Deputy Secretary of the answering respondents complied with the order of this court. Then, my lord, will kindly come to paragraph 20. I say that not in respect of one candidate, Noor Huda Khan.
Yes.
In the present proceeding, where the prayer is for treating the writ petitioners equally with recommended non-trained candidates, the issue may not be gone into. However, if this Honorable Court passes a direction, the alleged ambiguity pertaining to Noor Huda Khan can again be looked into